Okay, so we are back for the part 6. This is me re-recording it because I am really sorry, guys. I don't know why the audio didn't work, but yeah, there was no audio, which is really frustrating because that took 15 minutes to record. Okay, so I'm just going to go straight into it. We know how it all works. I've actually finished recording all the other episodes for the rest of the document now, so I'm just going back to do this so I can just put it straight to published. All right, then. So this is obviously the Vanzan one, the bit we're all excited about. Wayfarer, on or about October 1st, 2024, that being the date that the subpoena was issued, because the Vanzan lawsuit was initiated on September 27th, and then the subpoena, which was served on Jones Works, was issued on October 1st. On or about October 1st, 2024, taking advantage of New York rules that permit discovery even before issue has been joined, and of the fact that no defendants had been named who could thereby invoke the court's process on their behalf, redacted. Lively. Undisputed that redacted, and Lively respectfully refers the court to the cited source for its complete contents and disputes any summary or interpretation inconsistent therewith. Wayfarer. Such requests were made even though the complaint did not refer to the film or Jones Works at all, nor redacted. Lively. Undisputed, and Lively refers the court to the cited source. Wayfarer. The filing of the lawsuit and the issuance of the subpoena created a legal mechanism by which Lively, through Vanzan, could ostensibly claim to legitimately obtain the documents Jones had found on Abel's phone. Absent a court's compulsory process, Jones could not simply turn over records she found on one of her employees' phones. Lively. Undisputed that the initiation of the Vanzan lawsuit and Vanzan's issuance of a document subpoena to Jones permitted Vanzan to request the categories of documents therein, but otherwise disputed that absent a court's compulsory process, Jones could not simply turn over records she found on one of her employees' phones, which the cited evidence does not support and which is a legal conclusion. Okay. Okay, so that's all admitted. Next, waiver. Redacted. Vanzan voluntarily dismissed the case on December 19th, 2024, without any defendant ever appearing in the action. Lively. Undisputed. On December 21st, 2024, the New York Times published a 4,000-word article entitled "We Can Bury Anyone Inside a Hollywood Smear Machine." The article cited documents from Abel's phone that Vanzan had obtained by invoking the court's process in a case against 10 anonymous defendants. It appears that Jones agreed to turn over the documents without any protective order or measure to prevent their disclosure. Lively. Undisputed that on that date, the Times published their article. Lively refers the court to the cited source. Disputed that the article cited documents from Abel's phone that Vanzan had obtained, which is not supported by any evidence. I would argue, well, how the hell else did those documents, which has now been admitted, had been obtained by Vanzan, who is Lively, through the subpoena she gave to Jones Works, and they came from Abel's phone. How else did the New York Times get them and put them in a 4,000-word article that, favored Lively and also included her confidential CRD complaint? How else? I hope at trial they say to her, explain how they got there. Okay, next. The New York Times article asserted that Baldoni and Heath had violated physical boundaries and made sexual and other inappropriate comments to, and then instituted a retaliatory smear campaign against Lively. The New York Times article included a link to Lively's California State Administrative complaint, which had been filed the previous day. Lively, undisputed, and Lively respectfully refers the court to the cited source for its complete contents and disputes any summary or interpretation consistent therewith. So I'm going to do my just the undisputed, but because I'm not reading all of that. The next paragraph is redacted. Lively disputed the evidence cited does not support defendant's assertion that redacted. Undisputed that the quoted language appears, but Lively refers the court to the cited source. Through the administrative complaint she provided, Lively and or her agents told the New York Times and other media that Baldoni had abruptly pivoted away from the agreed-on marketing for the film to emphasize his support for survivors of domestic violence. Okay. Lively, undisputed that Lively CRD complaint alleges in the days leading up to the film's release, Mr. Baldoni abruptly pivoted away from the film's marketing plan, etc., etc. But she refers the court to the cited source. Also disputed as to the defendant's assertion that the statement is false, which the cited evidence does not support. Okay. Through the administrative complaint she provided, Lively and her agents told the New York Times and other media Baldoni and Wayfarer had not used nudity riders or intimacy coordinators on set until her intervention, and she did. It's in her CRD. She also did an interview where someone actually said to her, oh, you had to step into the role of intimacy coordinator, didn't you? And instead of saying, no, I didn't, we had them, she implied that there was intimacy coordinators, but they came later on. But her initial response was, and that should not happen. That should never happen. Something like that it was. Instead of saying it didn't happen, it was, that should never happen. Something like that. Undisputed that that Lively's CRD complaint alleges that Wayfarer failed to adhere to guild rules as well as Lively's contract and standard industry safety protocols with respect to nudity and intimate scenes. Lively refers the court to the cited source, disputed that defendant's assertion that the statement is false, which the cited evidence does not support. To the contrary, the evidence cited by defendants shows that redacted. And then there's more stuff that's redacted. Through the administrative complaint she provided, Lively and or her agents told the New York Times and other media Baldoni had suggestively told Lively her neck smells so good during a shot. Video captured of the scene demonstrates that statement was false. She's going to try and say it's not false. We all saw that video. Undisputed that Lively CRD complaint alleges that during the slow dance scene for a montage with no sound recorded, there was sound recorded, Mr. Baldoni leaned forward and slowly dragged his lips from Lively's ear and down Lively's neck as he said, it smells so good. And none of that happened, by the way, which was not part of the script. Lively respectfully refers the court to the cited source. Disputed that the video captured of the scene demonstrates that statement was false. It absolutely does. He did not drag his lips down her face. To the contrary, the evidence cited by... the evidence cited by defendants is a video footage from the scene in which Lively's character gives birth, which is true, actually. Exhibit 74, and I know this because I've been waiting for it to become unsealed. That is actually exhibited as the kind of behind the scenes footage of the birth scene. It is not the slow dance footage. So Wayfarer made a little boo-boo there, but I mean, still, we've all seen the slow dance footage. Okay, next. Through the administrative complaint she provided, Lively and or her agents told the New York Times and other media Baldoni had routinely degraded Lively by finding back-channel ways of criticizing her body and weight, including by pretending a scene in the script required him to lift Lively so he could ask her trainer about her weight, and by referring Lively to a weight loss specialist. Those statements were false. She did make those allegations, and they are false. Undisputed that Lively CRD complaint alleges that Baldoni also routinely degraded Lively by finding back-channel ways of criticizing her body and weight. He didn't. And that Mr. Baldoni shamed her for her body and weight. He did not. Quite the opposite. And Lively respectfully refers the court to the cited source. Disputed that defendant's assertion that statement is false, which the cited evidence does not support. And then there's a bunch of stuff redacted. The next point is redacted. Lively undisputed, but refers the court to the cited source. Next, as discussed above, formal negotiations regarding the terms governing Lively's potential performance in It Ends With Us commenced in mid-December 2022, when Vanzan sent Lively's representatives a draft offer letter which Lively would agree to perform in the role of Lily Bloom in the film. Lively, undisputed. The first draft of the offer letter defined producer as Wayfarer Studios or the designated production service entity. Lively, undisputed. On April 2025, Lively's lawyer revised the offer letter to define producer as It Ends With Us movie, an entity that Lively's representatives understood was Wayfarer's designated production service entity for the film. Lively, undisputed. The offer letter set forth basic parameters of the anticipated agreement, which endured throughout the drafting process. Lively's loan-out company, Blako Inc., defined as lender, would agree to furnish Lively, defined as artist. When they define Blake Lively as an artist, I imagine art with crayons, or, like when they saw like a dead cow in half or something like that. I do not imagine, like Vincent van Gogh. I don't imagine the Mona Lisa. I don't imagine that kind of like art. I think she does, but there we go. To perform the role of Lily on specified dates. Lively undisputed that Lively's loan-out company, Blako Inc., contracted to provide the services of Miss Lively to perform the role of Lily pursuant to the offer letter. Lively refers the court to the cited source. Lively would also receive top billing and an executive producer credit. Lively undisputed that the cited source reflects that she would get these things, but she refers the court to the cited source. In exchange for this and other consideration to Lively, It Ends With Us movie, ultimately defined as producer, would pay Lively a substantial upfront fee to be placed in an escrow account held by Lively's agent, WME, before filming would commence, plus compensation based on the performance of the film and other contingencies. Undisputed except as to Lively's compensation based on the performance of the film and other contingencies which remain subject to negotiation. Next, following several months of negotiations and exchanges of drafts, the offer letter was finalized in early May 2023 and dated March 17th, 2023. Lively undisputed that the final version of the offer letter dated March 17th, 2023 was circulated on May 4th, 2023. The offer letter did not contain any terms regarding sexual harassment. Lively undisputed. Wayfarer itself, as opposed to It Ends With Us movie, undertook no obligations under the offer letter. Lively disputes this. The evidence cited does not support defendant's assertion that Wayfarer undertook no obligations under the offer letter. To the contrary, the offer letter was signed by Ms. Mezian on behalf of Wayfarer Studios, and It Ends With Us movie contracted with Blakely Inc. in its capacity as an LLC established by Wayfarer in 2022 in connection with the development and production of It Ends With Us. Next, the offer letter expressly and unambiguously provided that full execution of a long-form agreement to be subsequently negotiated was a condition precedent to It Ends With Us movie's obligations thereunder. I'm not going to read this. If you could just pause it, because I'm now exhausted. I won't read that. I mean, I've read them before already when I've gone over the actors' loan out agreement and the offer letter. Okay. Lively disputed the evidence cited does not support defendant's assertion that full execution of the long-form agreement regarding the terms of Miss Lively's engagement was expressly and unambiguously a condition precedent to It Ends With Us movie's obligations to Miss Lively under the offer letter. To the contrary, the cited evidence specifies as a condition precedent execution of an agreement in a form reasonably acceptable to all parties. And Miss Lively respectfully refers the court to the cited source. Further disputed that paragraph 13 of the offer letter was an ongoing and operative part of the parties' agreement. The terms of the offer letter became binding through Lively's reliance letter to Wayfarer, which expressly recognized the waiver of paragraph 13 through the parties' mutual performance, notwithstanding the absence of an executed long form, and then the rest is redacted. On May 8th, 2023, outside counsel for It Ends With Us movie, Joseph Lanius, sent Lively's attorney a draft actor loan-out agreement, i.e. the long-form agreement referred to in the offer letter. Lively undisputed that Joseph Lanius sent Lively's attorney a draft agreement on May 8th, although he did so on accident. The parties to the draft ALA were It Ends With Us movie, defined as company, and Blakely Inc., lender, with an inducement to be signed by Lively, artist. Lively undisputed. The first section of the draft ALA referred expressly to conditions precedent, stating that conditions precedent to companies' obligations under this agreement included company's receipt of executed copies of this agreement signed by lender and artist, as well as receipt of the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. Lively undisputed that the quoted language appears in the cited source, but she refers the court to the cited source. An inducement provision included at the end of the draft provided that Blake Lively would be personally bound by the terms of the ALA. It further provided that for the purposes of any and all workers' compensation statutes, laws, or regulations, an employment relationship exists between It Ends With Us movie and myself, It Ends With Us movie being my special employer under the agreement. Lively undisputed that the quoted language appears in the cited source, but Lively respectfully refers the court to the cited source. The draft ALA contained an entire agreement provision, section 18, which provided that a document setting forth standard terms would be included as part of the ALA and stated, and again, if you pause to read that, but we have read it before. Lively undisputed that the quoted language appears in the cited source, but Lively respectfully refers the court to the cited source for its complete contents and disputes any summary or interpretation inconsistent therewith. The standard terms attached as Exhibit A contained numerous provisions designed to protect It Ends With Us movie, including a notice and cure provision titled Company's Breach, which ruled out any breach in the event of a cure, as well as an express damages limitation, which ruled out any consequential damages. So, Oh, I'm trying to move my screen. Sorry. Oh, I do not like my laptop sometimes. Okay. So if you just pause there, should be able to read it now. It's stopped moving around. I'm really sorry about that. I'm having a mare today with technology. Okay. Libely undisputed that the quoted language appears in the cited source. She refers the court to the cited source. The standard terms contained an additional merger provision, section 15.3, which also included non-waiver language, libely undisputed. The standard terms also contained a lenders and artists remedies provision, section 15.6, stating inter alia that the rights and remedies of lender and artist in the event of any breach by company of this agreement or any of company's obligations hereunder shall be limited to lender and or artist's right to recover damages, if any, in one or more arbitration proceedings. Libely undisputed, but refers the court to the cited source. The standard terms required that any notices to It Ends With Us movie be in writing and addressed to It Ends With Us movie for the attention of Jamie Heath. Libely undisputed that the quoted language appears, refers the court to the cited source. The next one is redacted. Libely undisputed that after several rounds of negotiations, Miss Libely's counsel circulated revisions to the agreement on April 18th, 2024, which included provisions redacted. The next one is redacted entirely. Libely does not dispute it, whatever it is. Okay. The first phase of filming It Ends With Us began on May 15th, 2023, with the ALA still unsigned and no agreement reached on its final terms. Libely undisputed that the first phase of filming began on May 15th, 2023, and that the agreement was not signed at the time, but disputed that the terms were not substantially finalized, and disputed to the extent that this assertion suggests that the agreement was not a binding, enforceable agreement. The face of the CRA itself confirms that the parties had reached agreement on at least the material terms. Further, as of the date the CRA was executed, both parties had commenced performance of their obligations under the agreement. It Ends With Us movie was not asked to and did not pay for any medical insurance for Libely, undisputed. Libely and her team negotiated every aspect of her work, dictating numerous terms and conditions, including minute details, such as the right to exercise pre-approval over the days when shoots would take place in locations other than New Jersey, as well as her travel and accommodations in those locations, the financial bonuses she would receive if the film hit certain benchmarks, the credits she would receive for her work, including an executive producer credit, the identity of her makeup artist, wig maker, and body double, the ability, and Baldoni's body double, let's not forget that, the ability to offer a meaningful consultation over the look of the role, ad campaign, and release pattern, and the time she would spend on set and traveling to and from her home in New York each day. And we saw all those negotiations in the email. Libely definitely had the power over that. And even approval over the screenplay, the director and her co-lead actor, and she did have right of approval over Baldoni in both a directorial capacity and an actor capacity. Libely disputed, of course it is, disputed that Libely and her team negotiated every aspect of her work, which the cited evidence does not support. No, but maybe not every single one, if we're being pedantic, but it's definitely all of that and then some. Lively and her representations negotiated for certain terms and conditions beyond SAG minimum protections. And such negotiations were consistent with work condition negotiations for. It's redacted, right? But I will stake everything I own. Underneath that redaction says an actress or an artist of Blake Lively's caliber, or an A-list actress of Blake Lively's caliber. It will say something like that. There will be something highly egotistical in there about her. Well, I'm special, so I need special treatment. I'm a Nepo baby. I'm being a bit salty now, I think, because I'm so tired, and because I have to re-record this as well. I haven't spent an hour recording it once already. Okay. Nonetheless, although the parties negotiated for more than a year, Lively never signed any long-form agreement setting out the complete terms of her engagement with the film. Lively undisputed that Lively did not sign the agreement, but disputed that the parties did not reach agreement on the material terms of the agreement, and that the agreement was not binding as to those terms. The rest is redacted. The next one is redacted with a bunch of stuff that's redacted, including Lively's response. Okay, the next one's redacted. Lively's response. Undisputed that negotiations over the terms of the agreement resumed and continued after the CRA was executed and filming recommenced, and that certain terms remain subject to disagreement, but otherwise disputed as misleading because the assertion that numerous terms remain subject to disagreement fails to account for the reality that redacted. With redacted and Wayfarer redacted. Right, okay, the next point is redacted. Lively undisputed that negotiations over certain terms to be included in the parties' existing agreement redacted. Lively's response is also redacted. And then the next point is redacted. Lively undisputed that redacted. However, the assertion that redacted. Next point. At no point during the negotiations did either side suggest changes to the entire agreement provision, the company's breach provision, the non-waiver provision, or the limitation on damages provision, nor did Lively ever seek to add Wayfarer as a party to the draft agreement, nor was Wayfarer ever made a party or signatory to the draft agreement. Lively. Undisputed. Similarly, at no point during the negotiations did either side suggest changes to, inter alia, the governing law provision, the services start date provision, the company's ownership rights provision, the sexual harassment provisions, save for the final sentence. See, for example, redacted. The next point is redacted. Lively, undisputed, but refers the court to the cited source. The next point is redacted. Lively, undisputed, and then everything is redacted. The next point is redacted. Lively undisputed that the last version of the agreement exchange was sent on July 2nd, 2024. Next point. Lively refused to sign the ALA. And here's where she changes the wording. Wayfarer's actual wording that she is supposed to respond to is Lively refused to sign the ALA. Lively's response, undisputed that Lively did not sign the agreement, which leaves it open to interpretation as to whether she refused to or she was precluded from doing so because of something, technicality, or because something that was in Wayfarer's hands. It's not the same. She's not, agreeing that she refused to sign the agreement. She's agreeing that she did not sign the agreement. Then that is very much open to interpretation and different to what Wayfarer said in their statement. And we've seen a lot of that throughout this document. Next point is redacted fully. Lively undisputed that redacted, but Lively refers the court to the cited source. And then the next point is redacted entirely. Lively undisputed that, and then everything is redacted there. I think that's another point then that is also redacted. Yes, because Lively responds undisputed, but that the quoted language and edit appear in the cited source, disputed that the terms of that provision, aside from the edited language, did not represent a binding agreement between the parties. Lively refers the court to the cited source. Next, the draft ALA contained a California choice of law provision. Lively undisputed. Next, Lively never signed the ALA or the inducement. Lively undisputed. Next, Lively's representatives sent a cease and desist letter addressed to certain defendants and others on December 20th, 2024. The letter was not addressed to It Ends With Us movie. Lively undisputed. Next, the cease and desist letter alleged inter alia that the addressees had breached the protections for return to production and or Lively's contract rider. The cease and desist letter did not allege any independent breach of the ALA. Lively undisputed. Next, Lively filed her initial complaint in this action on December 31st, 2024. Lively undisputed. Why is that? Then there's a bunch redacted. Lively undisputed that Lively seeks the categories of damages identified in paragraph 394A to E, and that the quoted language appears in the cited source, but Lively respectfully refers the court to the cited source for its complete contents. And then there's stuff that's redacted. Okay. Next point is fully redacted. Her response undisputed. Next point is fully redacted. Her response is undisputed. The next point is fully redacted. Now here, I highlighted this in my original video to highlight why this one was redacted. Family Hive. This is part of their deposition transcript. Family Hive are some kind of business partner, I think, or something to do with one of Blake Lively's businesses. I believe it's Blake Brown Beauty. But I have not looked into that for quite a long time, so I cannot remember. But they have been deposed, and there is their deposition transcript appears in Wayfarer cited it to support their whatever is redacted here, the point they're making. Lively does not dispute it. The next point is redacted in full. Lively undisputed that, and then that's redacted in full. Another point is redacted in full. Lively undisputed. Redacted in full, undisputed. Redacted in full, undisputed. This goes on for a little while. Another one is redacted in full, undisputed that, and then it's redacted. Lively, Wayfarer, redacted in full. Lively, undisputed that, redacted. And then finally, this is redacted in full. Lively, it's undisputed. And here is where we get to, and then we kind of start here in video 7. So I'm going to upload this ASAP to get it out. I'm really sorry about the technical problems with the audio within the first video, and my my touchscreen laptop kind of deciding to have a mind of its own with zooming in and zooming out of the document. I think I've had I'm having a bit of an issue with technical issues. However, I have to say my laptop has been going for about 6 hours doing videos today, so kudos to it. I would be lost without it. So I can't really complain in the grand scheme of things. All right, I'm gonna really get off this now, and then all the other videos are all scheduled to be released. I have got where is it? So I'll upload this immediately, and by the time you're watching this, well, you'll be at the end of it, actually. So I'm not even sure why I'm going to tell you that I'm uploading it immediately. Okay, part 7 is scheduled for it's 10 o'clock in the morning British time. So I think I'm 5 hours ahead of Eastern time, so that'd be like 5 o'clock in the morning Eastern time. And then part 8 is scheduled for 2 o'clock in the afternoon British time. So that would be 9 o'clock in the morning Eastern time. And then part 9, we finished with part 9, the finale. And that is scheduled for 6 o'clock in the afternoon my time, which is going to be 2 o'clock in the afternoon Eastern time. So that is all of 3, following this video, all 3 remaining episodes. Tomorrow I will have the replies from Wayfarer / Able to Lively / Jones Works for motion for summary judgment and motion for conditional summary judgment. So I will still have a lot to do tomorrow. I apologize for the volume of filing of videos as well. Some of them were obviously planned in this series, but then also we've had other things. I'm trying to keep up with it because this is moving so fast. It's and I'm just one person. So I am just trying to keep on top of everything. So I don't feel out of my depth. But obviously they're there, people don't need to rush to watch them immediately. By any means, take your time and kind of, watch what you want when you want to watch. But thank you for constantly unwaveringly supporting me and my channel. Very much appreciate you. Please don't forget to like and subscribe to videos as well. It really helps my channel out so much. And if hype is available, again, all helps. But thank you very much for everything. And I will be back, later on. Well, you will see my other videos. I'll be back tomorrow with the responses from Wayfarer and Able and anything else that drops in the meantime. All right, guys, have a good night.